We're very excited that we've managed to create a double panel. We do ask, our speakers are going to go ahead and accept questions after each presentation. So if you could please hold your questions, we'd appreciate it. And as well, we'd like to be able to get your questions on the tape that we're producing of this. So if you can just wait while I run around with the microphone, that'd be great. Let me go ahead and introduce our speakers. Miyun Park is a fabulous animal activist and the president of Compassion Over Killing, a nonprofit animal advocacy organization based in Washington, D.C. COK primarily focuses on cruelty to animals in agriculture and promotes vegetarianism and veganism. COK is amazingly effective for its size, and we are pleased she is here to share her knowledge and expertise with us all. Carter Dillard is currently a sole practitioner based in California. He left the U.S. Department of Justice, where he worked in Homeland Security, to devote more time to advocating for animals. He has worked with Compassion Over Killing and is a founding member of 4 Feet Forward. And Matthew Penzer is an effective advocate for animals as legal counsel for People for the Ethical Treatment of Animals, an organization that really needs no introduction. We are honored that he has taken the time to join us and to share his experiences with false advertising, most notably with the Happy Cheese Comes from Happy Cows campaign. So without further ado, let's get started.
Just wanted to start out and thank Laura and Jeff and Sunrise and Shelby and everybody who brought us here together to talk about these really important issues and for treating us so well. I know a lot of people traveled to come here, and I know how hard it is to be away from your companion animals, but thankfully, you'll get to see them very soon. I actually didn't pet a dog until I was 19. I didn't grow up with any companion animals, and I never even really thought about animals, except for these 2 canaries who were at my aunt and uncle's wedding. You know, just have that little splash of animal exploitation at a wedding. And I named them Donnie and Marie. This was in the 70s. And they died after a couple days. And that was pretty much my only experience, or so I thought, with living and dying animals. I used to go fishing all the time with my dad. I ate animal products at every single meal. And I got more involved in social justice activism when I was in high school. I would protest against apartheid in front of the White House and anti-military in front of the Pentagon. And I never, ever thought about all of the animals I was eating, I was wearing, I was using for entertainment. I just never thought about them. And I don't think, unfortunately, that I was that unusual. I meet people who became vegetarian or vegan when they were 6 or 8 or 10 because they just knew that it was wrong to be treating these animals who were unfortunate enough to be born as food animals. But I never thought about that until one day I got some unsolicited mail from PETA about factory farming, and I read it and I was completely horrified. I couldn't even believe it. But then I thought, I'm already such a good person. I'm already doing so much to make the world a better place that I don't really need to worry about non-human animals. But then later that day, I became vegan, and I've been ever since for about 15 years. Like Morgan said, the group I work with, Compassion Over Killing, we focus primarily on factory farming and trying to end the suffering of farmed animals. If everything else were equal, we would work on a variety of animal issues. But unfortunately, it's not. In this country, more than 98% of all animals used by humans are killed to give us meat, eggs, and milk. 98%. Now, that doesn't mean that animals languishing in zoos or on fur farms or in laboratories, that their lives aren't worthwhile, because of course they are. And of course we want to free them all and we want to save them all from so much suffering. But if you think that 98% of all of these animals killed are for food, that's why we focus on factory farming. We have a huge battle against us, of course. In the 3 hours that we're going to be here today, in this panel, 3 million land animals are going to be slaughtered. 1 million animals in just 3 hours, or just 1 hour, which is really hard to wrap your head around. And when you think that more than 95% of them are chickens, then you see why with COK we actually focus a lot on those chickens raised for meat called broilers and those chickens raised to lay eggs called layers. We know that most people have amazing compassion for animals. Zogby International released a poll in 2000, and they interviewed people who didn't know anything about modern egg production. They didn't know what a battery cage was. They didn't know what standard ag practices were. But 86% said that crowding 8 to 10 hens in a cage so small they can't flap their wings is unacceptable. 75% were against forced molting, the practice of withholding feed for these layers until they lose up to 30% of their body weight to jolt their battered bodies into yet another laying cycle. They said that was unacceptable. And 60% were against debeaking, slicing off the tips of unanesthetized chicks, their beaks, simply so that they will scatter less feed and they will engage in less stress-induced aggression. Last year, Gallup released another poll, and 62% of people said that they were in favor of passing strict laws concerning treatment of farmed animals. 62%. And I would guess that probably 99.9% of those people who were polled didn't know, again, about all of these standard ag practices. And why is that? Factory farmers and animal agribusiness have done a tremendous job of keeping everything hidden. Because if people knew what was going on inside of factory farms, on transport trucks, in slaughterhouses, there would be a massive sea change, because people are compassionate for animals. They have this innate nature, and they don't want to see suffering. And just like when I got that brochure about factory farming and I saw how horrible it was, but I didn't want to concern myself, because the problem seemed so big, especially when you're going up against a multi-billion-dollar industry that's in bed with legislators, that have commercials everywhere you look. But we have to get these images and the reality of factory farming into the public eye. One of the things that we work on is undercover investigations at factory farms, and in the past 3 years, we've done about 15 investigations, and we openly rescue animals from factory farms. And once we're done getting all of the footage and rescuing animals, we go to the press and we tell them, this is what's going on. We went in, we had to take these animals because they were in dire need of immediate veterinary care. And nobody cares, because there are no federal laws at all that protect these animals while they're on the farm, which is just unbelievable. These animals aren't even considered animals, they're mere commodities. So this is all just kind of a prelude, because Carter is going to talk about the legal issues about our false advertising case with the Better Business Bureau and different federal agencies. I wanted to take a couple minutes and show you some video clips from press that we've gotten from our investigations, just to show you the power of getting these images out there and showing what it is that agribusiness is trying to hide. So hopefully I know how to do this.
An animal rights group releases an undercover videotape that shows what it claims is animal cruelty at some Maryland livestock auctions. Eyewitness News investigates. Suzanne Collins shows you the tape and then asks the auction owner to explain his side of the story. Eyewitness News does want to warn you that some of this video you may find disturbing.
The group Compassion Over Killing took an undercover camera to 3 auctions in Frederick, Hagerstown, and Westminster, owned by B&J Auction. They claim their tape, made between October and December of last year, shows abuse.
We documented people kicking animals in the face, dragging animals who are too sick or injured to walk, carrying animals by their legs upside down or by their ears or by their tails.
The owner of B&J Auctions says in most cases on the tape, one employee is responsible for what's being called abuse, an employee they dismissed after just 3 weeks. He says the tape shows only a few isolated cases, not the whole picture. But the owner says he's learned from the tape.
You're never too old to learn, and you know, we're going to use this tape as a training tool to our employees.
Shortly after birth, They are ripped from their mothers.
The activist group promotes vegetarianism and kindness to animals. The auction house comes from a different perspective, providing farmers with livestock meant for food. On the tape, the activist group claims electric prods are used excessively. The auction owner says animals do get caught up sometimes, but they use prods sparingly. The owner of B&J Auction says some of the mistreatment seen on the tape is not his employees at all, but instead farmers coming to or from the auction, and he cannot control their behavior. The tape claims gates are slammed on animals unnecessarily and they are forced through narrow chutes, and there are dead animals.
Nobody wants damaged goods. So, I mean, sometimes the animals come in damaged. It's out of our control.
Suzanne Collins, WJZ Eyewitness News.
The animal activist group says people bothered by the treatment of animals at auctions should protest with their plate by going vegetarian.
Right now, here are some of the other stories making
Logo is on the eggs in your fridge, and if it is, you won't want to miss a special investigative report tonight, including some exclusive video that might make you think twice about what's on your breakfast plate.
Well, tonight the egg industry is under fire because of a controversial seal of approval, and that seal may be on the egg carton in your refrigerator.
As Jonathan Hawgood reports now, several groups claim that the seal is nothing but consumer fraud.
Dave and Anne-Marie, we discovered that most eggs you buy have an animal care certified seal on them. Probably makes you think you're buying eggs that come from chickens that are humanely cared for. But Eyewitness News 5 has obtained disturbing undercover video of an egg-producing chicken farm in Maryland that animal rights groups say prove otherwise. We warn you, some of the video you're about to see is disturbing. Eggs, wholesome, healthy, and high protein. And now egg producers have enhanced their cartons with this logo, Animal Care Certified, to make you feel even better about buying them.
I'm hoping so. I'm hoping they're just not sitting in their little box. I'm hoping that they get to walk outside and eat some grass and stuff like that.
But walking outside and eating grass is far from the reality of how many egg-laying chickens live. Eyewitness News 5 obtained this exclusive undercover video of an egg farm in Maryland. An egg farm that labels its eggs as Animal Care Certified. But do you consider this Animal Care Certified? Hens packed in cages so tightly they can't move. Most of their feathers gone because of the overcrowding, and their beaks seared off so they won't peck at each other. Another industry practice, starving the birds for weeks so they'll lay more eggs.
Thirsty.
The egg industry should not be labeling eggs from these horrific conditions as Animal Care Certified.
So how can they? The egg industry started using the Animal Care logo 2 years ago after animal welfare groups criticized their practices. Here's what the vice president of the United Egg Producers says about the disturbing video of these chickens.
That is not a typical condition within a typical egg producing facility. Farmers go through their chicken house daily. They look to see the condition of the birds.
Clippin says a panel of independent scientists came up with the care guidelines, but animal rights experts say those guidelines aren't making the birds' lives any better. And they're not the only ones questioning the Animal Care Certified logo. In November, the Better Business Bureau called the logo misleading. And when we asked shoppers, that's exactly what some of them thought.
I don't know how they can put this on here. What is care then?
Amy Critton says she won't buy eggs that come from caged chickens and shells out extra money to buy cage-free or free-roaming eggs. Those chickens must have better lives, right? After all, you're paying more. Regular large eggs cost about $1.59, cage-free eggs $2.69, and the ultimate egg, cage-free, free-roaming organic, almost double at $3.49. So besides better chicken feed, what are you getting for your extra $2?
Cage-free hens oftentimes are sitting shoulder to shoulder on the ground of windowless warehouses living in their own manure.
Here's a picture of broiler chickens. Paul Shapiro says this is also what a free-range hen house looks like. There may be an opening at the end of the warehouse, but Shapiro says they usually lead out to a tiny area, unable to accommodate more than a few birds out of thousands at a time.
Free-range chickens do go outside. But bear in mind that when they're outside, they're exposed to the elements, they're exposed to parasites, they're exposed to predation. So you have to ask yourself, which is more humane?
Animal welfare advocates say it would be more humane if the hens had enough room to flap their wings, weren't starved or mutilated, practices that are already outlawed in Europe.
The fact of the matter is that these birds are still abused, and the egg industry shouldn't be labeling animal care certified on their egg cartons when their hens are living in conditions that are so abusive that if they were forced on dogs and cats, it would be illegal.
Now, there is no state or federal law regulating the treatment of egg-laying chickens. Animal advocates say if you think chickens should be treated better, contact your legislators and tell them to outlaw those cages we showed you. Meantime, the United Egg Producers are appealing the Better Business Bureau's ruling that their animal care certified seal is misleading. For Eyewitness News 5, I'm Jonathan Hawgood.
All right, thanks, Jonathan.
When you think of egg farms, scenes like this likely come to mind. But animal rights activists say this is often the reality. Hens crammed in cages, their feathers forced off, their beaks burned. This footage was taken by the D.C.-based animal rights group Compassion Over Killing.
She's badly decomposed.
In the past 2 years, they have broken into 3 Maryland egg farms.
The factory farmer's worst nightmare is activists with video cameras.
Paul Shapiro founded the group, which holds demonstrations on D.C. streets almost every week.
There's a video of factory farms and slaughterhouses.
That's where they show their video and PETA video of alleged farm animal mistreatment to get their message across.
I guess I just never really thought about it. Now that it's kind of in my face like this, it really makes me, feel how awful it is for these animals and how I really should, do something about it.
Hens who lay our eggs never see sunlight, they never touch earth, and they never even flap their wings.
Shapiro says he and other activists found horrific conditions on all the farms and add these farms are typical of ones across the country. What appalled them the most, cage size. A standard chicken farm generally houses about 100,000 birds, but keep in mind they can hold up to 1 million. They're kept in long warehouses in what are called battery cages. And they're pretty packed in there too. Keep in mind that the average size of a hen is about the size of a football. That means farmers must give hens about 48 square inches in which to live during their 18 months lifespan. That means they can fit about 8 hens inside of a cage much the size of this. But because of pressure from animal rights groups, the egg industry has asked farmers to give hens more space. And all that is required under the new regulations is for farmers to remove 1 hen from the cage. But keep in mind, they're not required to do so.
The industry right now is trying to come up with new requirements that would give them only a minimal amount of more space that still would not even be enough to be able to flap their wings.
But the egg industry says hens don't necessarily need to flap their wings and maintains making cages any bigger would be a waste of space.
The research showed that it was humane to have chickens in cages. In fact, they would prefer to be in cages.
Clippen is spokesman for United Egg Producers, or UEP, which represents 90% of the country's egg producers. He balks at Compassion Over Killing's findings, saying hens are actually more sanitary in cages because they don't peck their own droppings. Another issue, keeping droppings off the hen's skin and their feathers.
These hens are stacked 1 cage on top of the next cage below, meaning that oftentimes the manure from hens above will fall on top of the manure in hens in the lower cages.
The UEP denies it.
Every poultry farmer would look to make sure that does not happen. No one wants feces falling on chickens.
But sometimes the chickens fall into the feces. Compassion Over Killing took these pictures of hens in manure pits. Shapiro's group also documented dead and rotting chickens sharing cages with living ones.
And her head is resting on the egg collection belt. You can see these 2 eggs here.
And there's video of a hen strangled to death, apparently by cage wires. The egg industry says that may actually be the activists' own doing.
When they go in at night, the chickens are resting, the lights are off. When they turn on the lights, chickens are very flighty. They will respond to that. They may run to the end of the cage. They may hurt themselves because of what these groups are doing.
But animal rights groups maintain no one is looking out for the hens. And they're right. there are no federal laws protecting farm animals.
If the abuse that these hens endure were forced upon dogs and cats, there'd be prosecution in all 50 states.
In other words, owners can legally treat hens any way they want. The Humane Society says that's simply not right.
We feel that what is standard in the industry is inhumane. It doesn't take that much more in political will or in economics to give hens the facilities they need.
But the egg industry sees nothing wrong with the way they're doing business.
Science shows that the production practices, according to our guidelines, are humane. And that's what the industry is going to adopt, and that's what the industry is going to follow.
Meanwhile, Compassion Over Killing will continue to peck at the industry, hoping their weekly protests convince at least a few people to think before they buy. Now, a footnote to all of this, the egg farmers that do give the hens more space, well, you can notice their eggs on store shelves. They will have to have this certified animal care on side of the egg carton when you purchase those eggs. Now, just a side note, that more space, it is still smaller than the average size of a sheet of paper, which you can see here is 11 by 6. Will?
And Robbie, just to clarify, farmers don't have to increase the living space?
No, Will, this is absolutely voluntary on the part of the farmers, and they actually have 5 years until 2008 to do so. And a footnote, what we were talking about.
What it calls cruel conditions at commercial egg farms exposed to the public. Suzanne Collins reports the group claims it went into a Maryland farm late at night and videotaped these conditions.
We're in shed number 5 at ISC America. We've discovered this hen whose head is caught underneath this feeding rail.
The group Compassion Over Killing insists this video was made at ISC America Egg Farm in Cecil County. That company says it's not so sure because no one spotted any trespassers and the Eastern Shore Company has not seen the tape.
We found a bird who is dead in her cage. She's obviously been dead for quite some time, seeing how decomposed she is.
The activist group, whose members do not eat meat, claim sick birds go untreated.
We're talking about dead hens in cages with live hens, hens who are immobilized or entangled in the wires of their cages with no access to food or water.
The vice president of ISC America says it wants healthy hens because they will be more productive. The company follows long-term ag industry recommendations on animal welfare, and it says it does things like all chicken farms industry-wide. The group Compassion Over Killing claims that the cages used on this farm are very small, and if you divide that space by the number of hens housed in each 4-pound hen gets about this much space to live in. This debate over so-called wired battery cages has gone on for years.
There's usually 3 or 4 tiers of these cages, meaning that the hens who are living in the lower tiers have to live in the excrement of those above them. And hens occasionally are able to escape from their cage. When they do so, they fall into the manure pits below.
The group has letters from veterinarians who say the conditions seen in these pictures are cruel. ISC America says if the activists did trespass, they took a chance killing birds by bringing illnesses in on their feet. The group claims it took precautions.
We feel that that is very important work to do, to really expose the injustices that are committed by the factory farm industry.
Suzanne Collins, WJZ, Eyewitness News.
The group claims it took 8 sick birds from the farm and rehabilitated them.
Right now, here's some of the other stories.
Old MacDonald had a farm, E-I-E-I-O, and on that farm he had a chicken, E-I-E-I-O, and on that farm he had a pig, E-I-E-I-O, and on that farm he had a cow, E-I-E-I-O.
In the next 30 seconds, another 10,000 animals will be forced into factory farms. They will suffer painful mutilations. They'll be packed into cages so small they can't flap their wings. They'll be crammed into crates so narrow they can't turn around. When we buy meat, eggs, or dairy products, we support this cruelty. You know, it's so amazing to think that we have to talk about whether or not keeping hens in cages that are so small that they can't even flap their wings is humane. You know, the fact that these hens in 2008 will get 67 square inches of space when research has shown that she needs a minimum of 303 square inches simply to flap her wings. So we're talking about 67 square inches in 2008. The fact that we have to talk about whether or not caging hens in these wire mesh cages so that they will never once feel sunlight on their backs or give birth or feel the earth underneath her feet, that we have to discuss whether or not this is humane treatment, whether or not this is an issue of animal care and welfare. It just goes to show you how much work we have to do, which is one of the reasons that we do these investigations. I was talking to Amy on the shuttle over here. I grew up in D.C., and you know, there isn't much country around there. And unfortunately for me, who's totally afraid of the dark, and you know, I prefer concrete and street lights and you know, sounds of people running around, these factory farms are out in the boonies. So it's really scary and really dark. But I force myself to do this because people need to see what's going on. And as you could see during those news clips, the media is interested in showing the general public what it is that's going on because they themselves are shocked by it. I met with this reporter from the New York Times who was at the time the head ag writer, and I was pitching one of our investigations to her, and this is the head ag writer, and she didn't know what a battery cage was. But once we get these images out there and once we tell people what's going on and we say, don't take our word for it, do the research yourself, and here are some resources, get online, find more information, and just make an informed decision. Because with every bite that you take, you will be adversely or positively affecting the lives of animals because we obviously don't need to eat animals or their products in order to survive. But every time we do, every time we have a milkshake, every time we have an omelet, every time we have a chicken nugget, an animal necessarily is going to suffer and is necessarily going to die. So that's why the work that we've been doing and the work that PETA has been doing in terms of attacking agribusiness through false advertising suits and petitions is so important, because for those people who may not want to be concerned about animal issues, despite that inherent compassion most people have for animals, they don't want to be lied to, and they don't want to be deceived, especially in terms of advertising. So I guess we have time for a couple questions, and we're going to take more questions at the end. So if anybody has any questions, otherwise I'll turn it over to Carter.
I want to thank you all for coming. Obviously, it's very important, this work, and we think that false advertising law is a way to target the industry that's unlike any other sort of law. And first, I want to start with a few questions, maybe be a little more interactive. Do you all think that the industry coming out with something like an animal care certified logo, is there anything positive in that at all? Can anybody think how that might be positive? That's right, if they're establishing improved treatment for the animals that they comply with. Industry is responding to consumption and consumers. Consumers, they wouldn't put it on there if consumers didn't want to feel like the product that they're buying is an improved product in terms of the treatment of the animals. That's a lawyer's answer right there. A claim, that's right. It does give us a claim. And along those lines, I do want to make an apology about false advertising law. I've written something very much in support of it, but it has a major defect, and that is false advertising law, as it relates to animals, presumes their use and treatment. And to the extent that the movement is going away from using or treating animals at all, it fails us. We're talking about people buying free-range eggs. Well, if you're a vegan, you don't buy free-range eggs. So to the extent you're divorcing yourself from the treatment or use of animals, false advertising law is not a way to attack the industry. So it does presume some continued use of animals. That's one of its failures. Essentially what you've seen is the basics of false advertising. A logo that doesn't comply with the actual conditions. That is essentially it. But since it's a law conference, we'll sort of get down to the nitty-gritty of the rule on the subject. And in the next half, we'll actually have some examples and a little Socratic interaction for you law students that came in here on a Sunday to get it all over again. First of all, I want to talk about the 3 reasons why I think that false advertising law, to the extent you continue to use and treat animals, is so important. First of all, I would argue that unlike any other sort of law, false advertising law gets animal treatment in a public forum. Let me explain. The Animal Welfare Act, what's one of the major deficiencies? Anyone that was at Mindy's speech as well, it's where I was yesterday, probably knows this. What's the problem with the Animal Welfare Act? That's right. That's right. Anything else? And standing, that's of course a problem. Private citizens, groups like COK can't bring actions. And for those 3 reasons, the AWA doesn't give us a public forum to discuss animal treatment. And when I say a public forum, I mean a court. It can happen in the legislature, not in this legislature, not in this Congress, but it can happen there. But preferably, we lawyers can bring it by force to court. We can't with the AWA. Animal cruelty laws, again, normally they don't cover farm animals. Furthermore, we're left to recalcitrant DAs to bring these cases. They don't bring these cases. That can't help us. And in civil law, there's the major impediment of the notion that animals are property. So for those reasons, the normal forums for controlling how we treat animals fail when we want to use those forums to discuss animal treatment. False advertising doesn't fail, and here's why. There's 3 things at interest when you bring a false advertising case. 1, the consumer. 2, the consumer's perception of animal treatment. And 3, and most importantly for groups like COK and PETA, the actual treatment of the animals. That is an element of your false advertising case. That means you get to put on the parade of abuse that you've seen here today in a courtroom, in a public forum, with all of the media that results from it. That is the beauty of false advertising law. The second reason why I think false advertising law is so important is, again, to the extent we're presuming the use and treatment of animals, if you don't have educated consumers that are protected from fraud, I would argue that animal rights education and animal rights media is worthless. If people are educated to know how bad battery hens are treated, and they, by choice, go out and buy free-range eggs, if in fact those free-range eggs are created with as much or as near suffering as the battery hens, there's no gain for the animals. And all of the effort we've sort of taken to convince consumers, it's worthless because they're being tricked and their purchase decisions are actually going to harm animals. So it's important to force the issue. It's also important because industry has an incentive to lie in these cases, much more than it has an incentive to lie, to commit false advertising in other cases. That is because, as the program noted, these products, products which are more animal friendly, cost more to produce, and purchasers will pay more for those products. There's lots of surveys that, to assuage their guilt and conscience, purchasers will pay more money for products they think are humane. So for those 2 reasons, industry can double dip. They get more money at the point of purchase, they save money at the point of production by false advertising. And that is, as we discussed in the second half, false advertising as it relates to the use and treatment of animals is rampant. So we're going to urge you guys to get out there and start suing people. The third reason is that unlike a lot of legal forums, animal lawyers get a warm reception, relatively warm reception, when it comes to false advertising law. And that is because you are not there to protect the animal. I would think that's a good reason to normally go, but most courts don't. You're there to protect the consumer. And you know, in America, nothing's more important than the consumer. You go to say, I'm here on behalf of Joe Bag of Donuts because he's being tricked. And if he's being tricked, the free market isn't working. And what animal advocates have always been told is, don't regulate humans' behavior. If you want to do something, go to the free market. Convince consumers. So when you go to the court, you can say, well, we're doing what you said to do. We've educated consumers on how to make market choices and social change to better animals. And in fact, because of the false advertising, because of the fraud, it's not working. And I would argue that agencies and courts, with increased complaints and increased education on what I term ethical consumption, will be more likely to respond to these arguments and to crack down on the false advertisers. So having said that, in sort of a summary of why I think it's important, we'll sort of get into the meat of the actual law. False advertising has got a pretty simple definition, and we'll unpack it. This, by the way, is just a compilation of state law, federal private law, which is a cause of action known as the Lanham Act, and federal public law, which is under the FTC's Act. So to write a little nutshell on the law, we sort of bring one simple definition, and it's common for all of those. False advertising is a material representation or omission of fact likely to mislead reasonable consumers. Now, that's a mouthful, but anybody who's been through contract or torts in the past week knows that that's a relatively easy rule. One rule, and with it a few implicit exceptions, but it's pretty easy to remember. We can sort of take this apart with some examples. A representation, that can be express or implied. If you see a product that says free range on it, what do you all think that representation? Think that's, what are they representing, and is that an express or implied? That's okay, I'll jump in. But that's actually just not all that obvious. Like a lot of things, express in law generally means written. So free range is an express representation that the product is free range, whatever that means. What if we see a product that shows, for instance, an egg carton that shows a diagram, or rather a design of hens wandering around a bucolic field of grass? What's that? Now, they don't say free range. That's implied. They are arguably, and I think they are, implying that the eggs were produced by free-range hens. Do you infer a message from that? Does the term free range imply something? It doesn't have to because it's written, it's expressed. So they're stating something in one case, in another case, you're inferring it from the package itself. Omission. Remember, it's a material representation or omission. So what might be an omission? If you're in an area where people don't know what free range is, and your product is a result of an animal wandering free range around its 5-foot pen, it might be an omission to let people know that when you say free range, you mean free range of the animal's small pen. That is to say, you've got to presume something about what consumers are going to take away from the message you put on your product. And you've got to account for that in your advertising. If you fail to do that, that is considered a material omission. And that is also grounds for a false advertising suit. So that way, even if you don't have an explicit statement, you don't have an implied statement on the packaging, if the person's failed to mention something, that's a grounds for false advertising action. This came up in '87, I think, with an ALDF case called Provimi, where they took on veal producers in Massachusetts for not labeling their products with a description of how the veal was produced. And their argument was, it's a violation of state cruelty laws to produce veal. And under the consumer protection law, you are required to advise the consumer that you violated state law in making this product. And that was their argument. It didn't succeed for lots of reasons, mostly because the FDA was really occupying the field in the USDA at the time, and there were some arguments about preemption. But an omission is a basis for a false advertising claim. This is a fun one. When I say reasonable consumer, that can change depending on the group that the ads are targeting. And I don't know if you all have ever seen this horrific commercial in California that it's for the milk board out in California. But it's a commercial of these kids eating their breakfast, and the mom tells them they've got to drink their milk, and they sort of, no, we're not going to drink our milk. And they look out the window, and there's their old neighbor, really old guy, lifting his wheelbarrow. And as he's lifting it and looking at them, he lifts and his arms tear off. And his arms drop to the ground, and he's sort of like wandering around. And the mother says, you know, our neighbor never drank milk. And the kids furiously begin to chug the milk. Now, I would argue that that ad targeted towards adults is misleading, clearly. Mindy could probably explain the niceties of why milk doesn't have the health benefits that that ad suggests it does, or lack of milk doesn't have the horrific ramifications that that ad suggests. But the important thing for this example is that ad is targeted at children. And there are studies that show you can't target any ad at children without it being misleading because they don't understand ads. They aren't reasonable in the first place. So under the law, it's oftentimes the case that they're not considered reasonable. But you can't target ads at children, and you certainly can't target scary ads like that at children. The important thing here is when you get, you know, freakish clowns hawking hamburgers to children, you've got a basis for false advertising because children are an exception group. There's a whole part of the Better Business Bureau that is dedicated to protecting children's interests in false advertising. So look for children as a specific subgroup of the reasonable person. Material. What is a material representation? Bueller? That's right.
They threw it on the package, it almost seems like material because they think it's enough to put on there to help sell the product.
That's right. Material means it affects the purchase decision. The consumer relies on that representation. If there's something on there that the consumer doesn't care about when they purchase the product, it's no good for false advertising law. You've got to establish that element. Corey points out, well, it ought to be that the courts presume materiality because why would a producer go to the trouble and expense of putting an ad on a product if they didn't think it would affect consumer choice? It's quite a good argument. Under the law, however, courts will not presume materiality unless you can show that the message the consumer received from the ad is the same message that the producer intended to send. And that's sort of hard to do. That we're talking about getting a memo from something like the corporate offices and saying, we want people, when they see this picture of the cow wandering around the field with nothing else written on the label of the meat or whatever, to presume that the cow is free-ranging over a field. If they say this is the intent of our ad, then the court will presume materiality. But for whatever reason, as Corey points out, they don't make the leap that all representation should be material because their point is that the advertisers do advertise with intent to convince consumers, but it doesn't always work. They may put a label on there saying, well, I'm putting it on because it's going to convince the consumer to do this. Unless there's evidence the consumer actually got the message, it worked, then the court won't presume materiality. Lastly, we have second to last, I should say, we have the notion of subjective and objective. Again, it's easy stuff, sort of back to first-year law. I'll give you an example of an objective claim. Court, in a case long ago, was confronted with the dire social issue of whether or not frozen potato granules mushed into a little chip-shaped thing was actually a potato chip. And this was expensive, years and $1 million of litigation. I think Pringles makes these. I don't want to libel, slander anybody, but I'm not sure who the company was. But the question was, if you don't actually slice it off the potato and throw it in the pot, is it a potato chip? And in the end, the court cracked out Webster's dictionary. And they said, well, this is relatively objective. A potato chip is something that everyone agrees on based on Webster's dictionary as something you slice off a potato and it in a pot or fry it or something. That's potato chip, and having these these frozen granules, that's not going to cut it. Sometimes in animal advertising, the representation is technically objective. And so we're not really thinking about too much what the consumer's thinking. We're looking at what the objective understanding of that term is. And in that case, we're thinking about dictionaries. When I say humane veal, that is not an objective term. Humane means lots of different things to lots of different people. Even in the dictionaries, if you had 3 or 4 dictionaries, I imagine you come up with different definitions. That's where you'll have to actually figure out what the consumer's thinking. You won't be able to rely on objective evidence. Lastly, in the rule, which is material representation or omission of fact likely to mislead reasonable consumers, there's the of fact. And that's the important distinguisher between false advertising and puffery. Strange word. I don't know where they got that one from. But puffery is a representation of opinion. And the famous puffery case out of the 5th Circuit in Texas, again, over a dire social issue, was whether or not Papa John's statement that better ingredients, better pizza was puffery or whether it was false advertising. And the court said, no reasonable consumer is going to believe that better ingredients, better pizza is anything but Papa John's saying that they think their product is better. It's opinion, it's not fact. Now, if they'd said organic ingredients, better pizza, what do you all think would have been the result? It's hard to say if you guys aren't false advertising geeks like me and study it. Organic is actually a controlled term now. The USDA regulates the use of the term organic. That is relatively objective. And I think you could pull out the USDA regs and say that anybody claiming to make an organic product without complying with those regulations was false advertising.
What if they said great pizza cheese comes from happy cows?
Matt's got a great point. What about that?
Yeah, anybody? Please.
Very false. And I don't know. That's a good question. That's a good question whether that's objective or subjective. I don't think it's puffery. I think it's false advertising. But these cases are rampant, as I said. They're all over the place. The field is ripe for litigation. And the good news is in some circumstances, you can get damages. Find yourself a free-range producer. Find yourself a free-range market, a retailer, and convince them to sue under the Lanham Act. You get damages, lots of damages, which is something else that's unusual in animal rights case. You can forward those back to your deserving organization. Finally, we'll just quickly hit the ads themselves and the evidence necessary to make your case. First thing you need are the ads themselves. The court needs to see the ad that you're talking about. That's quite obvious. What's a little less obvious is you need the background to those ads. When you're in discovery or to the extent you're not in a proceeding and you have to rely on other methods, you want to go out and find what was the company thinking when they came up with this ad? What did they want to convey to the consumer? What sort of market research did they do prior to running the ads? What sort of science did they rely on for relatively objective claims? Why? Anybody want to take a gander as to why that information might be relevant later down the road? Well, remember, if you can show that the message that the producer intended to convey is the same message that the consumers got, there's a presumption that the ad is material and that it's reasonable. You don't have to prove those two things. So if you do come across evidence that a producer wanted to sell free-range beef by simply putting a picture of a cow wandering around a field when in fact those cows were not, you won't have to go through the trouble of doing surveys and all of that. You can simply say, this producer intended to convey this message. And that message is presumed reasonable and it's presumed material. So some of the background research can really help. In the case we'll discuss later on, the animal care certified case, it was especially helpful because we found that they did a survey in which 46% of those surveyed assumed that animal care certified meant certified by the government, not by the UEP. So that sort of background is important. In some cases, not all, but I mean, surveys are important, and I usually say that that's in the cases where they apply, they're the most important piece of evidence. They'll also be the most litigated piece of evidence. Constructing an admissible survey is hard. Constructing an unimpeachable survey is almost impossible. It'll always, if you get the survey in, it'll always come down to the weight the court wants to afford it. But the weight, and at times its admissibility, comes down to a number of very complex factors. And the only thing I can advise is if you're going to do surveys and you can afford it, you got to get experts to do the surveys and to appear to testify in court on behalf of the surveys they've conducted. Oftentimes groups can't afford that. We sort of took a middle of the road and hired an outside firm that was going to do it very cheap, and we designed the surveys by ourselves. But if you can get experts, that's probably the preferred way, because there's a laundry list of 20 objections and basically motions to exclude that people will attack those surveys on. Everything from leading questions to not getting a proper sample group to not doing double-blind testing to taint your survey takers, to not even crazy things like not ordering the questions correctly. You might have 10 questions. If the question in which the consumer presumes the better animal treatment is the first answer on each one, well, guess what? People are lazy when they take surveys, and they usually just click. They want to get out of your face, and they just tick the first question. So that's a leading. If you don't sort of switch up the questions, that can be considered leading, and courts have dismissed excluded surveys on that basis. Finally, there's sort of two, I just want to say, second to last, there are two other things you might throw in. Consumer affidavits in these cases. Not so relevant because we're talking about the reasonable consumer and not the consumer you represent as the litigant in the case, not consumer X. But those affidavits are important because they give a face and they give a narrative to your claim. And this consumer can explain to the court in detail why they personally were duped by buying eggs that they thought were free range when they in fact were not. They can explain the emotional damages, the economic damages. Maybe they've been buying free range eggs for 10 years. And they can also explain the thought process that they went through before buying the eggs. That really fleshes out the case. In terms of what the court would rely on in its final decision, probably not much. But in terms of the thing that the court will most likely flip to in your submission, I would argue that the consumer affidavits are vital. And lastly, there's extrinsic evidence, and this again deals with objective claims. If you have a claim that's sort of on the line, like well cared for. Say there's a zoo that's got animals, and it knows, thanks to the work of activists, that it can't simply run a zoo without convincing the would-be zoogoers that the animals inside are well treated. So that it has a huge sign up above the zoo that says our animals are well cared for. Well, of course you'll want to find out what consumers think by that, doing surveys. But also well cared for, sort of like Happy Cows Act. I mean, Matt's the expert there, and that's the seminal case on this issue that I followed to even think about our cases. But like that, well cared for animals might sort of ride the line between objective and subjective. And in that case, you want to pad your bet and do your consumer surveys, and at the same time get extrinsic objective evidence. In this case, I would suggest something like a veterinarian. Can a veterinarian tell you if an animal is well cared for? Probably. You take your animals to the vet to be cared for. It's very feasible to argue in court that term has objective, is by nature objective, and this person who is an expert on the subject of animal care can testify. So regarding the conditions in that zoo, this person will testify about the objective nature of the terms well cared for and whether the animals living in horrible conditions in the zoo are in fact well cared for. And as I said, you'd also want to do the subjective in case the court would lean that when you want to pad your bets. That is really the law in a nutshell. We have a little more time. I want to ask, we'll sort of start off to see if you guys have any questions about how to do these cases.
I'm kind of curious about standing. I think, well, for us, California is really the only jurisdiction where you don't have to have standing, you don't have to have an injury to bring a false advertising claim. And I guess even in D.C., you still have to have some injury. So the first part of my question is, what do you think qualifies as a sufficient injury for false advertising?
That's a good question. I haven't gone much into procedure here because Matt's really the expert and was going over that some. But I can tell you that essentially, when you're talking about federal court, you can't bring the claim at all under the FTC Act. The only way you can bring it is under the Lanham Act. And in that case, as I said, you've got to represent maybe a free-range producer or a free-range retailer. That's because under the Lanham Act, you have to be a commercial competitor to have standing. The way that the Act is written, in fact, that's not the case. It's got a very broad allowance, but several cases in all the districts, all of the circuits have interpreted the Lanham Act to require you be a commercial competitor before you bring the case. So in federal court, your only way is by having somebody that is being injured commercially by this thing. So say there's a wild animal sanctuary, there's a sanctuary 100 miles away from the zoo that's running its well cared for ad. You would have to find them as a plaintiff to establish standing with the Lanham Act in federal court. State court, it's quite different. In California, as many know, we have Section 17200, which really allows standing for a broad variety of claims against businesses based on their illegal conduct. And because the state statute prohibits false advertising, that's illegal conduct, and you have standing. The D.C. Circuit, D.C. does have a new statute, relatively new statute on the books that allows for a private attorney general action. That question, sort of whether you can bring a claim there and what sort of injury you need, I think is relatively untested. I think from the plain reading of the statute and it's in your materials that you probably don't need injury because it refers to bringing an action for the benefit of nonprofits, specifically for things like false advertising. However, again, to sort of pad your litigation, you want to include plaintiffs that perhaps for years have relied on these representations and have spent money in relying on these representations, and perhaps because the representations deal with mistreatment of animals, suffer some emotional harm as a result. You would want to add that then in for creation of a true case or controversy, a true injury.
Do you think that just purchasing a product in reliance on the ad, for example, someone sees the animal care certified and they think, okay, I'm going to buy it because it has it on there, or, some other issues regarding the benefits of milk, someone sees an ad, buys milk, and do you think that might be sufficient standing? And then I guess my other part of that is to bring a false advertising claim in a jurisdiction other than D.C. or California where you would have to show some kind of injury. Do you know whether injunctive relief is available in some states? And then would it be of any value to bring, as if you just have one person who's only there, they're not a class action, but just have one person, they relied on the ad, bought the product, the value of bringing a claim in one of those states?
I think almost all of the states follow the FTC, or the little FTC acts, and injunction is almost available for the cessation of false advertising in all of those acts. In addition to injunctive relief, where court will order the person to stop running the ads, and some of the injunctive relief also includes running corrective ads, which is the best part, because the advertiser has to admit that they've been lying. There are damages that are allowed in addition to the injunctive relief. Consumers can recoup the money they've lost. Now, the problem with that is, depending on the damages you're alleging, you arguably in DC and certainly in California, you simply bring it because people shouldn't be false advertising, and everyone ought to have the right to corral them.
So in the case of Animal Care Certified, would you bring a suit against the UEP, like United Egg Producers, or would you bring a case against the specific farms that are using that logo?
We'll, just anybody who shows up for the second half, we're going to discuss ACC in depth, but specifically, we did name the UEP because they are the group that created the ad. You name the producer because they're the ones that are sticking the ad on the product. You name the retailer because they're the ones who are carrying the ad that's stuck on the product. You can name the advertising agency in some cases that designed the ad. In this case, we don't know. It looks like the UEP came up with it themselves. At least at this point, we don't have documentation on who else it was. When we get it, we'll name that person. You name the full gamut of potential defendants who touched this ad. False advertising law puts everyone on the hook. So in that sense, it's good. While in many cases, plaintiffs are hard to come by, defendants are easy to come by.
Do you run into a lot of protective orders with respect to market research and the science upon which the defendant relies?
That is specifically under the FTC and under the Lanham Act and in state court as well. That stuff is oftentimes specifically protected. So you won't be able to sort of publicize the things that they were relying on to get to court. That's because there's proprietary interest in that.
Do you have problems with press releases for that reason?
It's a good case because, as sort of explained later, that we haven't gone into the full-scale litigation at this point. We've just gotten a complaint before the FTC referred by the Better Business Bureau. But in the cases where Nina showed you where they were present in the facilities, there wasn't any action to try and exclude that information. Simply because in the Better Business Bureau proceedings, there's no grounds for exclusion. In state court and those sort of things, there might be proprietary arguments why we can't get that in. But again, it would only be subject to a protective order, and the judge, jury, anyone making the decision would certainly have access to that information to establish the actual conditions, to establish the science on which the producers and advertisers were falsely relying. So you're right, it won't be as good to show that the actual product that Joe Vagadones is selling had caused harm to consumers, and then he should have known that before he put it on the market. Sometimes that stuff's proprietary. But at least when you're before the Better Business Bureau and you're filing petitions with state agencies and federal agencies, there's no opportunity for them to exclude this.
You mentioned earlier that sometimes you need a competitor for standing. Do you foresee any problems with competitor standing for a nonprofit organization, like you were talking about a wildlife sanctuary competing with a zoo? Right. And since we're talking about commercial endeavors here, are there problems there, and how would you address those?
That's a really good question, and I honestly don't know the answer to it. To be honest, that's something I would have to sit down and argue. I don't think that simply because you're a nonprofit, you're excluded from commercial standing. You didn't receive the attendees that you would have had the zoo not been false advertising. Your nonprofit might go under because it's not getting the press. It's sort of I know some sanctuaries that might have a no use, no exhibition policy. Some rely on that to get people to come and then make donations. They didn't get those donations because nobody was going because they're all going to the supposedly well cared for zoo. That nonprofit goes under. I don't see how, when the Lanham Act was meant to protect businesses, including nonprofits, from false advertising, how they could let groups go under because of the admittedly false advertising of a competitor. So I think there'd be a good argument. And actually, there's a case in California where
Has there been a free-range egg case brought?
Not to my knowledge. The term free range is not controlled by the USDA. As I said, the term organic is. And organic has certain implications for how animals are treated. The term free range, which is much more, I think, it's a much more loaded term than organic, has not been regulated by the USDA. I believe in the next year or two, the USDA is going to issue notice of intent to regulate those sort of terms. It might be the USDA, it might be the FDA. I'm guessing it's going to be the USDA. And they'll go through the notice and comment procedure to come out with a regulation regulating the use of that term. But they haven't yet. And so it's fair game. If it hasn't been regulated, everyone's using it openly. As you'll probably learn about more in the future, that's a great way to think about bringing a claim. You find out cosmetic, it says cruelty-free. You find out they've been doing graze testing. You get you get a survey together that explains to consumers what graze testing really is, and you ask them, when you hear the term cruelty-free, do you assume that the animal's subject to this sort of suffering? We get a lot of no's, and we on the basis to say that person shouldn't be getting additional market benefit of marketing with this term on which consumers rely. But I don't think it has been. So it'll be, unlike ACC, which we have a relatively narrow group of interests, that term is used by lots of folks for lots of reasons. So you'll get a lot of opposition. You'll really have to have an airtight case.
I work for a veterinary and medical device company, and I'm in the unique position that I approve all labeling and advertising before it goes out. And sometimes there's this attitude from sales and marketing where, you know, I rely on the FDA and I have to follow guidelines from FDA for labeling, but they'll say, oh, well, it's just vet use only, that's not regulated. So what would my response be to that?
When vets are buying, is this right? Are vets the purchasers? When vets are purchasing, they're acting as consumers. They're consuming these goods, and I think they fall under the same standards. Just because that's not the traditional market consumer, I think you step into the shoes of being a consumer when you as a vet buy something wholesale. And if a vet relies on statements which are misleading on the product that's wholesale, my guess is he would have an action. It depends on a very narrow reading of consumer statute, but that's my guess. As far as the FDA approval goes, it's a very complex issue about what the FDA really approves and what they don't. FDA, I can say right now, they don't go anywhere near animal treatment, no matter what they say. You look at their regs, they only care about health of animals and humans and the impact those drugs have on health. So to the extent that they'll say, well, we approve the label, and it happened to have an ancillary claim on there about animal treatment, so we must have approved that too. That's very suspect, and I think subject to challenge. So I would argue that the vets have a legal basis to challenge false
And like, have you heard anything about them stepping up? Or, I mean, I know they regulate medicine or drugs for vet, but, you know, there's nothing really for device.
I haven't.
Okay.
And thanks to Matt, and he'll be the next up, this stuff's just getting rolling. It's fresh for the year or two out there and start working people. But there hasn't been a lot of, certainly not regarding treatments. A lot of history on health and the drug's impact on a person's health, drug's impact on the animal's health in terms of animal husbandry, not on whether the product or the service and how it impacted the animal that created it or was used to make it, was used in the process. Those animal production claims, those ethical consumption claims, are not really there yet. I think the genesis of this was in the 80s. They came up with made in the USA labels. We want to make sure that people were getting sweatshop goods. They actually came up with a sweat-free label that turned out, I don't know, I think the thing was boxed here in the United States, but it was certainly made in the most horrific conditions abroad, and the FTC put the hammer on.
Welcome back to part 2 of legal actions against false advertising. And just a reminder for those who are joining us just now, I am trying to run around and get on tape everybody who's trying to ask a question or make a comment. So if you can just bear with me and pause while I run over you. Thanks.
Hi. Before I start, let me just get to one point to follow up on something that Carter was saying before when I asked the question about whether the scenario regarding Papa John's would change if the claim was great pizza cheese comes from happy cows. And the question is that actionable or not? In a very practical way, when looking at false advertising laws, there are you really have to look at what claim you are challenging, because there is a great part of that claim that I think is unchallengeable and part of it that is. I don't even know what great cheese is, so anybody can say great cheese comes from oak trees, and it would be a matter of opinion. Great cheese comes from happy cows. Is it better? My cheese is better than yours. My cheese is great. My cheese is superior. I don't know that if that's the basis for your claim, I'm not sure how you could bring that and sustain that. If you were saying that a happy cow produces better cheese than an unhappy cow, I'm still not sure how you prove that, because I don't know that there's any legitimate scientific basis for it, and I don't know that how you would prove that a reasonable consumer would base their purchasing decision on this cheese comes from a happier cow than another cow, so it's better and I'm going to take it. But there's an implied statement in that ad slogan, and this was really what we did with the Milk Board campaign lawsuit. There's an implied statement that if you're saying your cheese comes from happy cows, for instance, the Milk Board slogan is great cheese comes from happy cows come from California. We're not going to challenge the claim that your cheese is great or bad or better than anybody else's. I'm not going to challenge the fact that your cows may be subjectively happy. I'm not sure how you define that. But to the extent that that makes an impression in the consumer about the condition under which the cows are treated or the welfare of the cows, or that in the case of the California dairy ads, that you are giving an overall impression of the dairy industry that it's one that's friendly towards cows when it in reality sends 400,000 cows to slaughter every year in that state alone because they're too weak or debilitated to give milk anymore. Many of them can't even stand up. Their calves are sent to the veal industry to source that industry. The EPA says that the California groundwater basins have been polluted. Something like 42 of California's groundwater basins have been polluted by California's dairy industry. So the extent that you're saying great cheese comes from happy cows come from California, and you're talking about clean air and sunshine and showing these ads that depict the California dairy industry as some pastoral scene that is far from the reality, and don't give consumers any mechanism for determining that that's not the reality of the California dairy industry, either in the conditions under which the majority of cows are kept or in the environmental conditions that result from the industry. That aspect of the slogan, we think, is quantifiably misleading. So when you take one statement, and there are a number of different implications from that statement, and if any of them are misleading, that's the actionable part. So not necessarily that great cheese comes from happy cows or that my cheese is better. Most of that is just opinion, and while we may disagree with it and be thoroughly annoyed by it, I don't see that particular part of the claim would be actionable. We brought, as they said earlier, I'm with PETA, and we brought 2 so far litigations for false advertising, and then we filed a number of Attorney General complaints, which we'll talk about later as various options. One was against the state of California, their milk board, for false advertising in this dairy campaign that we were just mentioning, and the crux of it is that great cheese comes from happy cows come from California. It shows cows singing and joking and laughing about and enjoying the carefree life that any good dairy cow in California would, even though a dairy cow in California lives an average about 4 years before having to be sent to slaughter. About 40% of them, they estimate, are suffering from some type of infection, whether it be lameness or other infections or something else. They don't live in the green fields that are depicted in the commercials. The average national herd size for dairy cows is 60. In California, the average herd size is 720. They give more than 20,000 pounds of milk a year. They are repeatedly impregnated to keep them lactating. The male calves are of no use because they don't grow fast enough to be beef cows, and they can't be grown to be replacements for their parents, so they are sent to source the veal industry. There isn't a veal calf in this country that isn't the offspring of a dairy cow. That's where the veal industry comes from. All of that is legal. But the dairy industry knows that image, can you imagine a depiction of the dairy industry that showed that? It wouldn't sell anything, and they know that. They don't have to depict the actual conditions of the industry. There's no law that forbids them from doing much of what they're doing, and there's no law that requires that they disclose it. But there is a law that prevents them from misleading people about it because they know that people care about that thing. And those are the laws that we're looking at, and we're targeting specifically the impressions that they're giving, not specific statements necessarily, but the impression that they're creating. We talk about I think Meehan and Carter really have set the stage, talk about just how important it is that we challenge, that we get out there and challenge these companies that have more resources than any of us can imagine, and they know. The reality is they know that people care about animals. We know that nonviolence is an important value to people. We know that compassion is an important value to people. We know that if people made the association between the way they care about dogs and cats to animals such as cows or pigs or chickens that are just as capable of suffering, that from a business standpoint, that would hurt sales. The question is, we know that it's profitable not to take animal welfare into account. The value to a business of a chicken or a dairy cow or a single pig is minimal. It certainly isn't profitable to provide a chicken with more space. It's not profitable to provide to spend money on veterinary care for sick animals, and it's not profitable to tell people that those types of things don't make good business sense. There's no way to raise 9 billion chickens and say that welfare is our number one priority, even though that's what the industry would have us believe. What we can do, though, is prevent the industry, while it's abusing animals, from doing it in a closed door with the lights out and putting a pretty picture in front of them. If we can get rid of that picture, open the door and turn on the light, then law or no law, how long are they going to be willing to do that in plain view of everybody? And what the false advertising laws do, it doesn't change one bit of the conditions under which these animals are kept. Carter said that earlier, and he's absolutely right. The false advertising laws don't take welfare into account one bit, and they won't change the conditions or the treatment of these animals at all. What they will do is level the playing field that facilitates a dialogue about their treatment. Because there's no way that a nonprofit like PETA or COK can match the resources of any one of these industries. The California dairy industry alone is a $4 billion a year industry, and the state is the one sending their attorney general to defend the milk board in the lawsuit. So it's the state of California, the Attorney General's Office of California against me. And if we didn't have the false advertising laws, and if we didn't push them, there would be no way that we could even get a glimpse into the reality of what's going on in these industries to have a dialogue with people on a fair level. So when you talk about the law, you talk about false advertising law, I mean, the law itself, it really defines us as a society. It's the rules that we choose to live by. When we have a law degree, we get to protect those rules. We get to make sure that what they stand for is fully protected and exposed where it's weak. So we look at the false advertising laws, and we know from the polls that were cited earlier that the treatment of animals is something that people care deeply about. It doesn't matter whether it's companion animals or farmed animals. We know that our value system says that unjustified suffering is wrong. So misleading people about that is wrong as well. We came to situations with the California Milk Board, and also we filed a lawsuit against KFC last year. Now, to put it in perspective as to what we're dealing with and what these corporations are used to getting by with, before filing the lawsuit against KFC, I sent their president a 5-page letter detailing, I don't usually do this for a lawsuit, and I don't hand the other side a litigation memo that basically amounts to everything I'm going to argue in the case. But in this case, given the fact that KFC and its parent company's marketing budget for 1 year exceeded PETA's total operating budget for the next 100 years, I figured it couldn't hurt to try that first. Sent them 5 pages saying, look, I know you're going to be annoying, and I know we're not going to like what you say about the way you treat chickens, and I know we have a very different opinion as to what constitutes humane care. But you have on your website things that are flat out false. They were saying on their website that chickens raised for KFC suffer no injuries, that chickens raised for KFC suffer no pain. We know that 35 million chickens that are raised for KFC every year don't even make it to the slaughterhouse because the conditions that they're raised under are so intense that they can't survive it. They can't survive the 6 weeks from birth to the trip to the slaughterhouse. 35 million of them die. Millions more arrive at the slaughterhouse with broken wings and broken legs. And once they get to the slaughterhouse, we know that approximately, I think it's between 3 and 4 million a year, miss the cutting machine and the backup cutter and end up being scalded alive in the defeathering tank. So we know that when they're saying things like they guarantee that chickens arrive at the slaughterhouse free of injury, that they suffer no pain, that we use state-of-the-art slaughter equipment, these things are false. That chickens received no growth-promoting substances. They had that on their website. When these chickens have antibiotics added to their feed, a practice that the American Medical Association said needs to be phased out because it's dangerous to humans in the buildup of antibiotic resistance, but because of the numbers of animals that are raised in the agriculture industry, because of the conditions under which they're raised, these antibiotics are added to their feed to keep them alive, and they also average about between 8 and 10% faster growth with less feed than if they were not getting the antibiotics. So the industry adds them to the feed and put on the website, KFC put on their website that we don't give our chickens any growth promoting substances. I told them in the letter that's flat out false. If they cared, first of all, if they cared about doing the right thing, they would have changed their website, at least not to give inaccurate information. If they were even concerned that somebody like PETA, with our limited resources, would challenge them to a litigation that they know they could bury us in discovery, go on for years, and come out the other side of the litigation with somebody saying, well, this was our opinion, and you have your opinion, and it's a wash years down the line. They are very confident, and we know this from not only advertising, but from all the corporate scandals that have been in the spotlight recently, but have been going on for a long time. What they can get away with, they can't be trusted not to. I got a letter back from not from the president, not even from their legal department, which I would have thought if they were taking it at all seriously that they would have had a lawyer send it coming from one of PETA's lawyers, but from a public affairs officer saying, we disagree with you, we're not changing anything. And I can almost guarantee that they never believed that we would file a lawsuit because it hadn't been done in that context before, and we filed one. And when we filed the letter, we talked to the press and told them that they were lying about their treatment of chickens. Not one single media outlet covered it for the integrity of the issue that, hey, maybe they really are mistreating chickens, maybe they really are misleading consumers about that, and that's just wrong. That's unscrupulous. It's not right, and that's news, and it should be something that we should investigate in practice. Not one single media outlet was interested when we sent them a letter. I filed a lawsuit in July of last year, and it got picked up by every major media outlet in the world. It went on every newswire in the country and internationally. We were doing 3 days straight of interviews, and immediately after the lawsuit, KFC made a statement to the media that it was a frivolous media stunt, a frivolous publicity stunt. They hired the largest law firm, one of the largest law firms in the world, Skadden Arps, and within a month and a half, they were already asking for extensions and saying, all right, what if we changed our website? And they did. They changed their website, and while all this was going on, they had been giving out false information on their customer service information line, and they also changed that. And I told them, I said, look, give me something saying you're going to change the website, and give me the new phone script, and then we'll consider dropping the lawsuit. And I was surprised that they did, but they did. They sent us a new phone script, and they sent us something saying that, you know, we are changing it in response to PETA's complaints, so that after they changed it, and then they went to the media saying, no, this had nothing to do with PETA, and then we released the court documents, the whole point of, you know, they changed. They're still saying annoying things, and they're going to forever, and I will absolutely protect their right to do that because I want the full protection of the First Amendment, but I absolutely want to make sure that that it doesn't serve to protect the right to have those with power and with great resources to be able to mislead people and conceal unlawful practices or unscrupulous practices, practices that they know people care about. The only way, I don't think that if you look at any social movement throughout history, there was a legal battle to it and there was a social battle to it. And in order to move the public to get to where you want to be, to get, if you're trying to progress, whether it be women's rights, whether it be the abolition of slavery, whether it be anti-segregation, in order to be able to get dialogue on the table, in order to be able to deal with industry, you have to be able to take full advantage of the laws that say we're going to make sure that you have full rights of expression. We're going to make sure that companies aren't able to take unreasonable advantage of people, and that's really what the consumer protection laws were designed to do. They were designed to protect those without the resources to see the truth, to find out the truth, from being deceived in matters that they care about. And we know from poll after poll that animal cruelty is something that they care about. So we're doing that with the California Milk Board case, which, by the way, is currently on appeal because the issue that we've been having to deal with the last year and a half is the state's claim not that the ads aren't false or misleading, but that the government doesn't have to comply with the false advertising laws. And the state attorney general is arguing that even though there's no exemption created in the law, and the state's Agricultural Marketing Act says you cannot use false claims in order to promote any agricultural commodity, they're saying that this is our sovereign function and we can't be touched. We can deceive people and you can't do anything about it. And quite frankly, that principle alone, I think, was worth the entire litigation. But once we finish with that, hopefully we'll get to go back and litigate then the merits of the claim. The interesting thing was that portion of the case, the portion of the case where the state is arguing for the exemption from the false advertising law, was included in Business 2.0's magazine's worst 100 business developments of 2003, that the state of California is claiming that it can engage in false advertising without review. So we're dealing with that issue. It's before the Court of Appeals, and then we get to go back to the lower court to do the trial. Now, the interesting thing, and the reason that this becomes so important, is we happen to have found out during the course of all this that the Milk Board, before issuing these advertisements, held a focus group of 10 people to see what their reaction to the advertisements would be, and didn't say anything. But I managed to track down the people on the focus group, and 4 of them objected that it was misleading, and they issue the ads as is. If there's no review, if there's no way to go after them, then you lose the opportunity. First of all, it weakens the very purpose of the consumer protection laws. And you lose the opportunity to have that exchange of principles, that exchange of ideas, that exchange of values in a fair way. Now, we know that up until now, the false advertising laws had not been used for issues of animal protection, and that's one of the reasons why it's being talked about so prominently now. One of the things that we look at when we were first deciding whether to do something, actually file a lawsuit in the cows case, and then again in KFC, was if you're looking to challenge an issue of justice, you're not looking you're measuring your success differently. You're measuring your goals differently. You're not looking to see whether or not this case is more of a moneymaker than something else. When you were looking to say that slavery was unconstitutional, when you were looking to argue for the 50 years between the 1890s and the 1950s, when the Supreme Court said that separate but equal was constitutional, and then the same court said it wasn't, you're looking to say, is the law doing what it's supposed to? Is it protecting the values that we know it should be protecting? Is it standing for justice? And if it's not, do I have a credible argument to push the issue, knowing that I may very well end up losing because judges don't like to make new law, and none of us like to, I can't imagine what the people thought who first heard that, the world was round after believing for their entire lives that it was flat. The court is no different than public opinion. It changes with familiarity, but you have to go in with credible arguments, and false advertising law, there's no credible reason, was our initial thinking and the initial argument that I made. There's no credible reason, given the evidence that we have, that people care about the treatment of animals. There's no credible reason why any statements or depictions about farmed animals, whether or not it actually violates any federal laws, because there are none, but misrepresentations as to their treatment are issues that people care about, and if the law isn't protecting them, it should be. If the false advertising laws aren't being applied to them currently, then somebody needs to go in and make sure that they are. And if you lose the case initially, it's okay as long as you lose it in the right way. If you go in, you're credible, you're prepared, you're earning the respect of lawyers, you're getting judges and you're getting lawyers to think about things, to think about issues, to talk about issues that they hadn't thought or talked about before. For instance, why aren't the false advertising laws being applied to animals? That's an issue that people care about. Then you've gone a long way toward making the changes that need to be made in order to have the false advertising laws work in the full way that they're intended. In other words, in order to give consumers the power to make informed purchasing decisions based on issues that they care about. And all we have to show is that issues of the care of animals are issues that consumers care about. And that we have plenty of evidence to do. So what I was saying earlier is distinguishing between the arguments. The FTC has on its site a policy statement that gives a detailed kind of guideline about what they look at when they consider what constitutes false advertising. And a lot of states really model their statutes, or at least have very similar policies. So that's there in case anybody is looking at that. There are many different options and avenues that you can go to challenge false advertising. We were talking about California, which is where we brought our 2 lawsuits, because it has one of the strongest consumer protection statutes in existence. It's great in theory. If you're just suing for injunctive relief and restitution, not for yourself, but for those who were harmed, if you're in a position to know that, say, the animal industry is deceiving consumers, but the consumers aren't in that position, a position to know that, then you can bring a lawsuit, if you're not looking for damages for yourself, to stop the false advertising and protect those who don't realize they're being misled. It's great in theory, and the problem was it was being attacked because some unscrupulous lawyers realized that if I don't have to prove standing, I can just file a lawsuit and business is going to pay me to settle the case because even if they win, and even if I don't have a basis for my case, I can get past the initial motion to dismiss, and they're going to end up paying me to settle because that's cheaper than defending a litigation, even on the merits. So it really is unfortunate that the law is being attacked in the way it is, and that they're arguing for restrictions to what I think is a very well-intended law. But we talked about the issue of standing earlier. You know, whatever it takes. I mean, we have to be credible. We have to do the law. We have to pursue the law and push the law in credible ways. But we may have to find standing. And if it's a material issue, you'll find the standing. Somebody's harmed if they're being deceived about something they care about, whether it be a business competitor, whether it be individual consumer. They've had class actions, the McDonald's French fry suit, to name one that got a lot of play. We have filed petitions with state attorney general offices, consumer affairs offices that are designed specifically to protect consumers from companies and others that consumers don't have the individual resources to take on. There are 1,000 different ways that a case can be dismissed that have nothing to do with the merits. So make sure that there are many different options other than an actual lawsuit for fighting false advertising, even in the relation to the treatment of animals. You can do letters to editors, contact your legislature if you think that the law isn't protecting animals or consumer rights in the way it should. There are more options than it's only limited by what you're willing to look for, and they're all out there. And all you have to do is show that there's an issue out there that people care about, that they wouldn't support if they weren't being misled about it. Identify that issue. In this case, it's in relation to the treatment of animals, which we know is an issue that people care about. Identify that issue, and push it and challenge it. Whether it be in a lawsuit or in a petition or in a letter, you put the industry on the defensive because we know that the facts are on our side. They have the resources, but we have the facts because, you know, they're in the position of having to defend the way they're treating animals, and we know that. We know from the videos you saw earlier and much more that the way they're treating animals, they know they wouldn't be able to defend in front of the public. And that's the role of the false advertising law, is to make sure that the public has the opportunity to make those informed decisions. I think I'm about at the time for questions, and then I think Carter's going to go again. No questions? Is it because it was so informative and clear that it was just...
I was wondering where the statistics that you used in the beginning, where those came from.
Most of them come from industry itself. it's really interesting, but they come from the either the state or federal Department of Agriculture, industry publications. If you know that whatever industry that you're in, they have their own publications. I'm not sure how many people here subscribe to Pork Magazine or Dairy Today, but all of them have publications. They talk about management practices. They're not so. They're a little more careful than they were in the past. For instance, Feedstuffs magazine, which is a big industry magazine, once had an article that talked about the profitability of overcrowding pigs. So they don't do it that much anymore. But the information is out there. It has to be looked for, and it's certainly not obvious to consumers and not easily accessible, but it is there. And one of the most important things, whether it be animal issues or any litigation issue, and I'm sure that this is stating the obvious, but the knowledge is, of course, power. The more knowledge that you have and that your opponents think that you might not have, the more knowledge that you have, the more power you have to pursue your case. It's absolutely crucial, especially given the disparity in the resources that the people who are advocating on behalf of animals have in relation to the industries that are using animals. The allocation of resources is off the charts. So the one thing that we absolutely have to make sure that we do is not give them anything that will allow them to say, look, they don't know what they're talking about. They're a bunch of fuzzy-minded people who just want to cuddle with animals all day long, and they don't, and they're far from reality. We take excellent care of our animals, which is, if you look, is the mantra of every industry that's ever been attacked for any issue. There was a great article in Mother Jones earlier this year on the history of the abolition movement in England, and as it got closer to being challenged and the slave industry was in fear of being regulated, they suddenly issued this slave industry code of conduct that talked about the wonderful way in which slaves were treated and how protected they were from if they hadn't been involved in the industry, and how well treated they were, and the marketing. There was a comment from somebody within industry that said, well, look, let's stop calling them slaves and start calling them assistant plantation workers, and that will appease everybody. You look at the way industry responds to the prospect of being exposed and being regulated and having to change from considerations of strictly profitability, and they follow similar lines. The way to combat that is to do as much research as you can, have absolutely the undercover investigations that COK has done and that PETA has done have been absolutely amazing and incredibly powerful. Because as industry would have you believe that everything is rosy and happy, and the animals are on farms that people picture from hundreds of years ago, family farms with one cow, and you go out in the morning and sit on the stool and milk the cow, and it's just not the reality. And we have to research, but it's all out there to make sure that we're unattackable, and that's the only way to combat the resources that they have. We got information from an article in Hoard's Dairyman magazine, which bills itself as the magazine of the dairy industry. And it said that the American industry's failure to follow what's called the voluntary pasteurized milk ordinance or something of that nature in regulating the amount of what's called somatic cell counts in milk is considered, it could be very dangerous to the industry if people find out about it. Somatic cells are cells with a nucleus. They're basically white blood cells, pus, things of that nature. And they did a survey state by state of how much appears in milk. They said the National Mastitis Council considers 100,000 to be the upper limit of where milk should be considered abnormal. The author in Hoard's Dairymen said, we'll add a fudge factor of an extra 100,000. We'll double it. That's per milliliter, by the way. So we're talking about in the hundreds of millions by liter. The average U.S. state somatic cell content in a liter of milk comes to somewhere around between 300 and 400 million, and some are up in the 500 millions and 600 millions. So we got that right from industry. And when we came out with it, University of California Davis veterinary article said, well, we have to watch this one because this could be something to, could be really dangerous. And so the Midwest Dairy Association came out with an ad campaign saying, no, there's no pus in milk. So we are dealing with their misstatement about that in an upcoming project. But the information. The point is, the information is there. If you look for it, it's impossible to handle the 9 billion land animals that are killed for food in this country every year. The animals in the labs, the animals, the sea animals that are being killed, and keep it all hidden, much as they try. So, but it really does require looking for it. Sometimes it's in tax returns. I know that the industry recently built an organization called the Animal Agricultural Alliance as the independent scientific arm of the industry. What they don't tell you is that the Animal Agricultural Alliance, it used to be called the Animal Industry Foundation, and the board of directors was made up of people from the National Pork Board and the National Cattlemen's Dairy Association and things like that, but before they changed their name. And they also don't tell you that they share personnel and office space with one of the biggest lobby groups for the animal industry, the Animal Feed Industry Association. So they are pretty much one and the same, but you have to look for the information. It is difficult for them to conceal, though. Anyone else?
What do you know about, or what's the latest on GMO chickens? For instance, I've been hearing some things about manipulating so that they can be grown without beaks, that type of thing. What do you know about the latest on that? Like especially with KFC or whoever.
We don't do, PETA doesn't do much with GMO or non-GMO because it is more a concern of health issues rather than cruelty issues. I know there are groups that are looking at that and dealing with that. I think one of the biggest issues was with disclosure requirements in the fact that they don't have to say whether it's genetically modified or not genetically modified. So I've read about for instance, the tomatoes that were modified with fish oil in order to allow them to grow in colder temperatures. They use some kind of Arctic fish and inject and put them in the tomatoes. And I don't want to be eating those. I think there's certainly a good claim for a reasonable claim for false advertising. You just have to be careful the way in which it's phrased, which goes back to my earlier argument with the GMO or with anything else. The defense will be, well, we're in compliance with the law. We're not breaking any laws, so we can't be advertising falsely. What you have to look at for the false advertising law is not necessarily whether they're in compliance or non-compliance with an underlying law. If they're not, that's certainly good evidence that they are being misleading. But even if they are, if they are being misleading about an issue that is of importance to people, that's preventing people from making informed choices, which they have the right to do, then you have a good basis for a false advertising claim. The specifics of GMO chicken, I don't know. Hi.
This question's for anyone to answer. How do you go about trying to get your video, your undercover video footage on TV, which would be extremely powerful and effective, and I'm sure there must be a lot of obstacles to doing that?
Well, it's interesting because we try to buy ad space every year with the footage that we have that we know exists, but we either get, no, that's not appropriate for television, or no, we don't take issue ads on television, which we hear a lot, which is absurd. And even though the airwaves are public, theoretically, the government has given them to the networks and the FCC to regulate out, and then they do what they want with them. So we've explored constitutional arguments and First Amendment arguments and other things. But and if anybody has a good one, I'm open to it. But generally, other than a news program, like the clips you were seeing, network television is involved in entertainment, and stirring up controversy and possibly offending and losing business from big industries is not a way for them to continue their profit-making activities. So other than breaking an investigation and then showing it on the news, it gets very difficult. And we have it on our on websites and talk about that whenever we can. But that it's always a challenge.
One of the great ways to get these images on TV is simply to become a member of your local cable access station. We have documentaries that are airing all across the country for free, simply by people who pay the $20 or $30 membership fee, become a member of their local station, and they get these programs on the air, these documentaries, which you can get from us or PETA or Mercy for Animals or any other organization in the country. In the first half of the panel, I showed 2 commercials that we produced, and those are actually running on MTV right now in 5 different cities across the country, and it wasn't easy getting them on the air, buying the ad space. But every time we contacted a different cable provider in a different city, we provided them with backup documentation so that we could prove every statement that was made in the 30-second clip. So it's, like Matt said, it's definitely not as simple as, if you're a cover girl and you want to have some makeup commercial on the air. But we can do it just with a little bit of persistence, and doing the cable access thing is just a great way to use this relatively free service to try to combat the multi-billion-dollar advertising budgets of animal industry.
Have you had any luck with public television stations? I saw that on Bill Moyer's Now, The Matrix was shown a few months ago.
That's some of the best luck we've had. I think what Meehan's statement was really right on the money, because even public television stations, which rely on donations from the general public to continue, they're great about showing much better than the networks, obviously, about showing informative types of issues, but and there have been documentaries that have been done about animal rights, the animal rights movement, about the industry, about various issues involved. But on a day-to-day news type of issue, it's very similar to, unless there's something breaking, unless there's something immediately happening, it's very difficult to get mentioned. And the whole purpose of, a lot of the PETA always and others get accused of simply existing, because they're interested in publicity. The reality is that with 25 billion animals being killed for food in the country every year, with animals in captivity, chickens completely excluded from the Humane Slaughter Act without protection, these animals are subject to abuses that are almost unimaginable, and the only way to even begin to stop that kind of cruelty is to bring awareness to that, to what's happening, so that you can talk about it, so that you can discuss it, and and empower people to make choices in their own lives that will stop contributing to it, and demand that either the law be changed to protect the values that we stand for, the nonviolence and compassion, or that it be better enforced or better applied. And it really is one of the media provide one of the few outlets to be able to reach that many people, to be able to deal with an issue on that broad a scale. And so what I look to in the law is where I'm able to find a place in the law that protects that ability to communicate with people, that protects that ability to empower people to make those choices in relation to false advertising laws. I mean, that's what I'm looking to really push. And then in other laws, issues of cruelty or laws not being specifically applied, then I'm pushing those too, but obviously for a different purpose and to achieve a different goal. All of it is related to the same overall purpose, and that is making sure that if the law is our system of providing rules to achieve justice in whatever situation that what we're looking at, whether it be a dispute between two people, whether it be a crime committed or something of that nature, or whether it be the treatment of animals, that the law has to be our mechanism for protecting our social values. And if it's not, it requires lawyers who are willing to stand up and say, if it's not, then it's our role to push it until it does, whether it be false advertising or whatever other issue. And false advertising laws really are now just beginning to realize their power in relation to the treatment of animals.
When you do get something on television and an industry representative responds as the egg guy, whatever.
You mean when they say it was the investigator who caused the cruelty?
Right.
Okay.
Is that false advertising, and is it actionable?
It depends on how they say it. They're getting much more careful, but that's a good sign, because if they weren't, that would mean that, I mean, they're so big and so powerful that if they are changing to respond to what you're doing, then as long as you know you're pushing for good, you're pushing for a just cause, you're on the move. Yeah, they're being much more careful, and KFC and its parent company got together with their lawyers after the initial lawsuit, and we're very careful. They can couch it in terms of opinion. This is not the type of conduct that conforms to our policies of how animals should be treated, and we won't stand for that, and we'll make assurances that this is not the type of conduct that that we will allow in our facilities. Well, yeah, but there it was. Well, that was the investigator's role. You saw in those clips that they blamed the investigator. The investigators came in, and that's what killed the chickens. So, yes, you've got a long way to go, and it is going to be very difficult anytime that you're looking to make a difference for a cause, whether it be through the law or otherwise. But if you're causing them to change the way they act, then something you're doing is working. Carter's going to go and do some more fun stuff.
I don't know how fun it'll be, but
no, it'll be fun.
To drill you guys on the standards that we were talking about earlier, and for those of you that weren't here, the standard is a material representation or omission of fact likely to mislead reasonable consumers. That's what false advertising is. So you can make your own assessment as to whether Clippen's statements were or were not based on that standard. I do know that Clippen is no longer with that organization. Probably, his disappearance was shortly thereafter, that sort of bumble. So what I've done is I've got some slides of ads. Now these, I've got to say, I've moved the text right up to the picture, so these are modified. These are not the actual ads. I want to make that disclaimer right now. But what we can do is sort of apply that standard and see what's going on in terms of whether these folks are trying to dupe consumers and whether consumers can make ethical choices despite this. And what you should be doing as attorneys to protect ethical consumption. So it'll take me just about a minute to get this set up. Everyone make that out okay? Might dim the lights if we could a little bit. I do want to say I can tell there's a lot of good ethical consumption in this room. One way you can tell you're at a law conference is if normally well-dressed law students and attorneys have the ugliest shoes